So first of all, I want to thank Mr. Asad Jamal for the invitation to visit this fine institution, and I want to thank everyone for coming to this very important talk. And I want to thank my co-panelists too for such excellent presentations. And await readers. I'm going to be going a little bit out of turn because I think that my presentation falls on Mehrab's quite well. So I want to pick up on something that was said at the very end, that history is repeating itself, and not just in the sense of the colonial history in 2022 in Pakistan, but also history from 2009 to 2012 in the Supreme Court of Pakistan in Islamabad. So I think one of my two major impressions of the litigation that is going on in the Federal Sharia Court right now is why now, right? So it's 4 years after the passage of the 2018 Act. I guess the petitions were filed in late 2020, 2021. Still, normally if there's an objection to an act, especially something so important as an Islamic objection, you would think that it would be filed promptly after the legislation of the act. So, one big question for me when the litigation started in the Federal Sharia Court is really why now? What is happening now that is different than in 2018 in regards to the issues being raised? The second major impression after observing but also reading about the proceedings in the Federal Sharia Court over the past many months is that many, if not all, of the issues being raised in the Federal Sharia Court were issues that the Supreme Court discussed quite extensively between the years of 2009 and 2012. So yesterday, today maybe there was a report on a proceeding that happened a few days ago in the Federal Sharia Court in which the Chief Justice was asking questions of the government as to why different homes for intersex children were not being, different assistance programs were not being made available, and what more could be done, and these sorts of questions. And this is the same kind of questioning of government officials and government policy and government neglect of transgender community, quadriceria community that happened over the course of 3 years in 2009 to 2012 in the Supreme Court. So I guess there were some different issues that were arising in the Supreme Court at that time, I think because of the political context and the post-2008 lawyers movement, the movement for elections, immediately post-Musharraf, etc. So voting rights were a big issue in the Supreme Court. So many quadriceria folks, trans folks were, for a very long time, had showed up at voting booths and had identification cards with their photo that did not match their current appearance. And so election officials would turn people away from the voting booths saying that this is a fraudulent identification, this is a fraudulent attempt to vote, and this has been a problem which had disenfranchised, which had prevented many transgender people from voting in many elections. So that was a really big concern at that time. Relatedly, access to educational institutions or any other sort of like public program in which production of your Shinakti card was essential, and government officials would take a look at the Shinakti card and say, this can't be you, right? So trying to solve a lot of these issues were there in the Supreme Court. But these are very, very complicated issues involving many, many different agencies, many different views within the community itself. And so the Supreme Court acted as as an outsider. The Supreme Court, in this public interest litigation, if you will, acted as a kind of legislative assembly for about 3 years. Trans people were invited into the proceedings, spoke to the Supreme Court justices directly. There were questions from the Supreme Court to members of the community, to different advocates, to many different government officials from every single province province, multiple departments within different provinces. And so there was a huge back and forth exchange of papers, reports, documents, recommendations, programs, all this sort of stuff. And so, the Supreme Court file is like this big from this time. Now, what's interesting is that this has kind of been forgotten, even though it happened only 10 years ago. And one of the questions from my research is, why has it been forgotten? And there's, I think, many different ways to answer this, but something that's very interesting from my perspective is that most of this file has never been published. Okay, so there were, over the course of 3 years, there were probably, I want to say, close to 15 hearings at the Supreme Court, if not more. I think about 15 that I have documentation for. And there are only 2 very, very short published decisions in the PLD. And the short decisions are not even the most important ones. And so it's almost out of the stack of paper, just 2 random pieces of paper were randomly printed. Okay, and these become the landmark judgments. And when that information is not out there for people within the legal community, certainly, to see, I think they start to forget about what happened in the Supreme Court from 2009 to 2012. There's also not information easily available for lawyers litigating these issues subsequently, for judges in the different high courts. And I don't want to, of course, I don't want to speak for the Federal Sharia Court, but I wonder if they have taken a look at this large Supreme Court file from 2009 to 2012. And there might be many reasons why they want to rehear these issues, but it is striking to me that there was so much discussion, so much input from hundreds of different people and departments. And then there was all the discussion around the legislation and the passage of the act and all the different, I didn't even know about some of those proposed bills, like the one from 2012. So I'm learning quite a bit myself here. So there's been so much discussion, and now we're having this discussion again. So one thing that I think about also as a legal scholar, and I think that many people in this room will also be interested in, is how legal and judicial institutions work or don't work, and how we can improve operations. So case backlog and case delays, there are obviously huge issues in Pakistan. There are huge issues in another country that I do research in, India as well. And it's always been a struggle to think about how do we make the system work more efficiently and actually provide relatively quick, speedy, and low-cost justice. So with the Federal Sharia Court proceedings, I was surprised that they took the case because it had happened, it had been filed so late after the passage of the act. But then when I looked at the initial petitions that sparked the case, and I'm still gathering information, but I've written a little bit about this in the Melburn Asia review, so you can take a look at that. I was, with all due respect to the petitioners, I was shocked at how unresearched these petitions were. So they were very short, and they made a lot of allegations against the act, against conspiracies supposedly behind the act, but gave the court and lawyers, when they put a petition in front of a court, it is part of the lawyer's responsibility, as I understand it, to help the court understand the issues. There wasn't a lot of helpful Islamic guidance provided in these petitions. So very slim contents on that front. And on the basis of that, we now have this major case, which is relitigating not only the Parliament's Act, but also what the Supreme Court did for 3 years from 2009 to 2012. So, yeah, it's a confusing situation, and it does seem like a lot of history is repeating itself on a lot of fronts, including an institutional history, again, the Supreme Court litigation, and now the rehearing of all these issues. I wanted to speak to a couple other things that I think that I can be helpful on. So the situation in India, it's come up here and there in this discussion. It's also come up in the federal Sharia court. So 1 year after the passage of the 2018 Transgender Persons Protection of Rights Act in Pakistan, India passed the 2019 Transgender Persons Protection of Rights Act, the exact same title. And this India Act was a response to a 2014 Indian Supreme Court decision on transgender rights called, people call it NADRA. So it's, sorry. NALSA. So the NALSA decision is kind of the copy decision, if you will, but very different. It wasn't conducted as a PIL like the Supreme Court did in 2012. The Supreme Court gave opportunities for many people to make submissions in that case, and they heard from a lot of different people, but it didn't occur over as many years as the Supreme Court case did. Now, it also took India quite a bit of time to come up with this act. There are many similar things between the 2019 Indian Act and the 2018 Pakistani Act, but one major difference is that there is no right given to individuals to self-declare their gender. So the Indian Act sets up medical boards, which it's complicated, it's a bit confusing, but in a number of instances, these medical boards are where a person is supposed to petition to change their gender. Now, the rules were issued after this act, and my understanding is that with the rules, the role of these medical boards is far, far more diminished. But when the 2019 Act was legislated in India, there was huge uproar from many members of different trans communities around India. And there's actually a case in front of the Supreme Court that's been filed challenging the 2019 Act, saying that it's in violation of the Supreme Court's 2014 NALSA Act. So let's see what happens here. But these medical boards, in the petitions to the federal Sharia court, or the two initial petitions that I saw, it's interesting, and it's I think worthy of highlighting and then discussion. The strong suggestion is made that Pakistan as an Islamic republic should adopt secular India's model of doing gender identity and establish medical boards that will control the gender identity of individuals here instead of allowing self-declared gender identity. So I think it's important to know what is actually being argued in the court, in the federal Sharia court by different people. It's our press reports are great, but sometimes they don't express or not able to express the full complexity of what is happening in petitions, counter petitions, court hearings, and so forth. So the other thing, people changing the genders back and forth, and what people can get up to when they change genders, and there was a case involving potentially same-sex marriage that got a lot of press recently. It was heard by both in the event of the local high court. And so, there's a worry that, well, we allow people to change gender, then there's two women, one of them can change their gender to male, and then they can have, an Islamic marriage. These issues, I think the way that they're being presented they're panicky, and they also don't take account of two other issues that I just wanted to mention. I'll just mention one because I know the time is short. So these issues have also, before same-sex marriage in the United States, which is very recent, before same-sex marriage in the United States, these issues came up in different states around the U.S. as well. So, for example, there are a couple cases in the state of Texas in the south of the United States where Texas refused to allow gender self-identification. They said, no, the sex that you were born with is the sex and the gender that you will have for the rest of your life. Very strict. No allowing of any changes of gender, even if you've had sex reassignment surgery, even if you completely, if you transitioned. So what happened in Texas is you had same-sex marriage was not allowed. This was 25, 30 years ago. You had male-female couples in which the male did a gender reassignment surgery or sex reassignment surgery and became female. Okay, so it was a male-female couple. The male did sex reassignment surgery and became female. The state, people tried to invalidate this marriage. So different busybodies said, we have a same-sex marriage going on here. Same-sex marriage is illegal in Texas. But Texas said, we don't recognize transgender people. This person is still a male. So this is a heterosexual union. Even though in the reality of life, it was a same-sex couple. There were multiple cases like this, and not just from Texas. So controlling people's gender identity, you may think that you're stopping same-sex marriage, but you are actually encouraging it in other situations. So it's like a lot of things in law, it's this very kind of double-edged sword. The last thing I want to say, and I'll just speak briefly about the U.S. Because some of the stuff that was said in the petition to the Federal Sharia Court about an international satanic conspiracy, I think that was the exact words. And usually in these contexts, the United States is the lead Satanist. But this 2018 Act, it was passed when Trump was president. Trump was no fan of LGBT people in the United States. It's a very weird, all conspiracies are weird, but this is an especially weird conspiracy if you think that the Trump administration was somehow behind the passage of the 2018 Act. So, these are complicated issues everywhere. There's a lot of debate, disagreement, life experience shared everywhere. There was no consensus on this in the United States. Certainly the United States was not in favor of trans people when this act was being debated and passed. So I'll end on that note.